What is a subpoena?
A subpoena is issued by the court. It's a document that compels an individual to appear in court at someone's trial, either a civil trial or a criminal trial, to give testimony on your behalf. If you make a threshold showing that that individual's testimony is relevant and material and there's no legal privilege, that is, there's no bar to that individual being compelled to testify, you can make that individual come to court, raise their hand, and testify under oath at your trial.
Can you avoid a subpoena?
In a situation where you may not be within the county, you can still be compelled to testify in certain circumstances if you file your subpoena with the clerk of the court and that testimony is relevant and material. If you're in another state, there's a uniform act that's designed to secure the appearances of witnesses out of state. But there's a bunch of hoops you've got to jump through, and it's not going to happen like that.
Are there penalties?
You decide that you don't want to show up that day because you've got Astros tickets or you want to play on your Facebook page, you can be brought before court, held in contempt, and fined up to $500 and given 30 days in jail. This is not a laughing matter. The Constitution says that the right to have witnesses testify on your behalf is a big damn deal.
How do you get a subpoena?
Generally, you have to be physically served. That's usually either by the bailiff or the process server of that court or by a private individual. But in certain circumstances, you can also be issued a subpoena via registered mail, certified mail, return receipt requested. But part of what figures into the process of whether you have to testify is whether you've been lawfully served.
Can I plead the Fifth?
The Fifth Amendment, for those of us who didn't sleep through civics class, is that you have a federal constitutional right not to incriminate yourself. That's why we see everybody from mobsters to child molesters to, oh yeah, Donald Trump taking the Fifth Amendment if they believe that an answer they'll give under oath is likely to incriminate them. So in the context of subpoenas, you can't subpoena somebody as a witness who you either know or should know is going to take the Fifth Amendment.
Is there a term you want more explanation about? Leave us a comment below, and we'll see about working on that next.